Any mention? Supplementary cause list, item number 1.
May I please, Your Lordship?
Yes.
My Lord, this is application under section 482 for quashing of the proceedings pending before the special POXO court at Ripoi district Nompo, my Lord. Here, my Lord, the parties, the parties, the prosecutrix and they are adolescents, my lord. Both the adolescents, my lord. The very purpose, the fact that I have come before my lord, is that in the trial, the victim, so-called the victim girl, has very clearly stated that they had an affair. They were having an affair. So in this course of their relationship, they had an illicit relation once. And now, my lord, and even the mother, what happened was that this girl, she left the home on her own. And she has, while leaving the home, she has written a note.
What is the age of the victim?
My lord, there is no certificate to prove, but then it is stated to be 16 years. my lord, and for every cognizance or cognizable offences by committed, purportedly committed by the same person while holding the same office, my lord, and the allegations of misappropriation or misuse of the official positions, can several FIRs can be lodged. Under that circumstances, then I'll have to undergo 7-time imprisonment. So this is a question, my lord. So
If you have committed 7 different acts, different crime, then definitely why not?
my lord, this, when we see the inquiry reports, my lord, and the FIRs, my lord, it will clearly speak that it is it is, of course, may be at different stage, but it appears to, it shows that is of the same transactions, my lord.
Where are the FIRs?
My lord, the FIRs are from page 94, page 92 onwards, my lord.
This is the first FIR.
This is the first FIR, my lord, and it calls about an inquiry conduct report. And also, my lord, it's quite, I wouldn't say that the FIR has been lodged by the same officers who were a part of the inquiry report. They recommend themselves to file an FIR, and they themselves files an FIR.
Is there any bar in law?
There is no bar, but one thing will, that I will argue later, my lord, that part, my lord. And
This speaks about,
this speaks about, my lord,
means 6 crore 35 lakh something. Supply of materials.
supply of materials, my lord.
Second FIR.
And the second FIR, my lord, this talks about the purchase of vehicles, my lord. This is a Scorpio.
Different, apparently different.
My lord. My lord, third talks about,
It's all right. We will examine the thing.
My lord.
Shall I anything at this stage?
So, since there is no prayer for interim relief, Your Lordship, let notice be issued. Your Lordship.
Internationals cannot come in clubbing.
So far, respondent number 3, 4, 5, and 6, these have been implemented by name. So notice will have to go personally.
Included by name.
by name.
Okay. These are all.
Oh, they are complainants. They are the complainants.
So you have included them by name. You have to take.
I'll take the steps, but they are the complainants, my lord. That's why.
Heard Mr. T. Ewan, London Counsel for the petitioner. Same issue notice written over 3 weeks. Mr. Shulai, London AAG. Yes, for respondent number 1 only, Mr. Oh,
1 and 2, Your Lordship.
One
1 and 2.
no formal notice is called for. With regard to respondent number 1 and 2. However, petitioner should take steps for service of notice upon respondent number 3, 4, 5, and 6. 3 to 6.
My lord. We'll take by tomorrow, my lord.
By within 2 days.
My lord.
List is after.
My lord. Highly obliged.
Item number 3.
Oh, yes, yes. Now, today, Mr. Mojiga has time for this court. Yesterday, he had no time.
So sorry,
All the
madam.
matters had to be adjourned just because of absence of Mr. Mojiga.
I'm so sorry, madam.
Yes, Mr. Mojiga.
My lord, in this case, my lord, one of the BSF personnel, my lord, he shot dead another BSF personnel, my lord. So, this is a case triable by BSF court, my lord, under the provisions
It has
of.
been investigated. Charge sheet has been filed.
Charge sheet has been filed by police, my lord, in the Sessions Court. Now, Section 80, Lordship is aware, we have filed an application for transferring the court to BSF court, my lord. Now, my lord, at that point of time, the BSF unit was in Garo Hills, my lord. Now, the BSF unit has already gone to Murshidabad, my lord. It's about 2 years, and now the BSF unit is about to move to Jammu and Kashmir, my lord. I've made a very categorical statement to that effect, my lord. Now the learned court below, my lord, only on the ground that PP, there is no PP, my lord. Almost 19 adjournments have been granted, my lord. And I have mentioned the date also, my lord. And it is a fact that there is no PP appointed for South Garways, my lord. But our difficulty, my lord, otherwise, because many...
So no order has been passed. Nothing has
order.
been impugned here.
Nothing has
It is
been impugned,
inaction on the part of the court.
my lord.
It's for
Inaction also on the part of the government, my lord, they are not appointing any
there is
PP,
some defect in your petition. See, Mr.
my lord.
See, cost title says 482. Come to your paragraph 1.
Oh, I'm so sorry, my lord.
It has to be corrected. See, if it is a writ petition, this court, as per roster,
No,
this court,
my lord, it's 482, my lord.
it has to be corrected. This is a statement or not?
You'll also allow me to correct by hand, my lord.
Can it be done?
Because the unit is in Murshidabad. Again, this will...
Yes, Mr. Khan.
It's not my mistake. Initially, I thought I should file under 227, my lord.
They say petitions filed under 226, 227.
Well, kindly allow me to correct by hand, my lord. Because it will be a long process. I have to get signature from Murshidabad, my lord, in West Bengal.
It can be corrected by hand. The office. Is it allowed? I do not know. Nowadays things are very strict probably. I have no idea basically. Can it be corrected, Mr. Khan?
Technically speaking, no. No. But then he has a practical difficulty, he says.
Yes, I understand.
In para 8, I have stated, my lord, the 19 dates. Almost only.
When did you file the application?
My lord, application is at page... in July 21, my lord. That is at page 27, my lord.
July 21 of 2000.
21, 16th of July. My lord, this is the notary date, my lord. It was filed on few days after that, my lord.
There is no date of filing.
It is not mentioned in this.
If the petition is filed, nothing, no registration or nothing is given. No filing number, nothing is given.
This is simply an application, my lord. It seems that no number has been given also.
Even if application comes, even petition for
My lord, some petition number
adjournment
should,
also is given some petition
petition number should have been there, my lord.
Yes, nothing is here.
Nothing is.
The problem is that if it is not there, how this court will be sure that you have filed? You say like you have to. There's nothing. Anyway, then you say you filed it on.
It is notarized in West Bengal, my lord, on 16 July 21.
Yes, and thereafter when is the date of filing?
My lord,
How
the
long-
dates in para 8, if you can correlate, my lord.
There are 8 of your petition. See, there is a huge contradiction then again.
No, my lord, before that, my lord, we filed another letter. I'll just point out that, my lord, that is at page... At page 22, my lord.
Yes.
This was submitted. This was because that time the deputy commissioner, the judiciary was not separated, my lord. In November 2020, this application was filed.
Here also again no date is there. It is the date of filing, nothing is there. And it is not a petition before this thing, before the court. Was it? It's a letter.
26/11, my lord. Well, this is a letter, my lord. It appears that the court said that you file a proper application. So,
So this
after
has, this is no value that way then.
my lord, but
It has to be disregarded.
my lord,
Now come to your petition. See, you say even if we go by the date of
petition, my lord.
the affidavit, let us say it is 16/7. Come to your averment, paragraph 8. You said court has given adjournment from 24/3. 24/3, that your petition was not on record.
But what happened, my lord? That application filed before deputy commissioner, my lord, that has been taken together along with that, my lord.
How do we know it? This is something, you see, this court would not like to pass any order without ascertaining that there really exists on application which is pending before the court. It should not be something like that, pass an order and subsequently it is found that no application has been filed.
Absolutely.
This will cause embarrassment.
Absolutely.
My lord, what I can pray, my lord, at this stage, my lord. The two options are either your lordship can call for the records, my lord, to examine, because as it is, nothing is happening in the matter. If the records are called for, my lord, then
And what about those apparent defects in your petition? Not only in one paragraph, now it seems it in two paragraphs. Some other paragraphs also have.
or my lord, exercising 482 if lordships, because only difficulty there is no PP, my lord. If this matter is transferred to Tura court, my lord,
482 is something unfettered. Court can do anything.
my lord, the lordship can transfer this from Southgar Bagmara to Tura, my lord.
Why should we do?
And
There must be a reason for not doing this. Your petition also is not very, you see, like, not very inspiring in the sense of, see, those discrepancies in date and all.
There are not only one, so many
If
things.
you notice, Mr. Khan, you can ascertain. If at all, see, basically this order will not affect anyone. If at all any application is filed, court below has to decide it.
Absolutely.
Only what is to be ascertained that whether there really exists on application. We will issue notice and then
And Lordship, in the meantime, if as he suggested, if the records can be called.
we'll do it. We'll wait for.
My lord, the two options, if subject to Mr. Khan's approval, my lord. Either Mr. Khan can explore the possibility of transferring this case to
That also he can do it. He can
Tura, my
use
lord.
his
Then
good office,
Tura Session
definitely.
Judge can examine, my lord,
So
whether
that-
proper application is there or not.
That is one thing, Mr. Khan. Please take note of his submission. He said around 20 adjournments were given just because of the reason that there is no PP.
Until today, there is.
That is
There
one
is,
thing you have to take care.
there is very, very unfortunate.
You
My
will
lord,
use
till
your
to,
office
and
to
my
basically-
instruction is that, my lord.
Lordship, I was only basically onto that.
Petition only prays for disposal of the this application prays for disposal of the petition which has been filed. So if that can be done, we can avoid one thing.
But then, Lordship,
Kindly you take instruction, I think.
I'll leave it to the discretion of the court. In case, because if that is the reality and he wants the case to be
We'll do one
transferred.
thing. We'll put this matter on some other day. You take instruction, and at the same time, you can use your good office if Mr. Majika's statement is correct. At least you can
Absolutely, absolutely. There is only limited issues that matter. The application could not be heard because of that reason. We'll take.
But the court cannot try also, my lord, because this is court also realizes that, but court is only expressing the difficulty without hearing
Court has to
PP,
pass some.
my lord,
This court right now will not transfer it.
my lord.
Let us see what order has been.
Mr. Khan can examine if they are agreeable to transferring the case, my lord.
Will be depending on him. Let him see. List this matter after 2 weeks. In the meantime, Mr. Khan, learned AG will obtain necessary instruction.
Lordship.
But lordship, we allow that correction to 27.
If it remains also, nothing will happen. I do not know whether that correction is allowed. I have to verify from the office. Because nowadays, handwritten correction is not allowed in the office.
Absolutely.
It creates confusion.
I'm so sorry, my lord.
But then, I think at least you tell your office to take care of those kind of things. Really confusing.
I'm sorry.
All right.
Item number 4.
Obliged.
Yes, what is this?
Please, Lordship, this is an application for restoration, Lordship, for quite an application.
This is a condemnation application. Condemnation.
Condemnation, no, the case got dismissed for default of the prosecution. And my lord, there is an application for delay also. So notice has to go first, my lord, to the respondents, my lord.
How many days delay?
There is 897 days.
Notice, definitely.
Dismissed in
Petition
February
897.
2021.
Lordship, what happened actually, unfortunately, it happened during the COVID-19. And there was,
They will appear for?
is for
You will
JHTC.
appear for?
I'm appearing for district council, my lord.
Which respondent? Which respondent?
And there is private respondent also, Lordship.
I'm for respondent number 3, my lord, 3, 4, 5.
345.
State is also a party.
State is also a part.
Respondent number 6.
No, respondent number 2.
Will issue notice.
Lordship.
Respondent number 2 and 6.
2 and 6.
Heard Mr. Petty Sangma, learned counsel for the petitioner. Issue notice. Returnable, they are from Garo Hills.
Yes,
Returnable
they're-
in
they're
3
from
weeks.
Garo Hills.
Returnable in 3 weeks. Mr. Kharmi appears
For two,
on behalf of
respondent
respondent
2
number
and
2.
6.
Mr. Day appears for respondent number 3, 4,
And 5, my lord.
5. We will appear for 2 and 6.
2 and 6, Lordship.
Mr. Kharmi for 2 and 6. No formal notice is called for with regard to the said respondents. However, petitioner shall take steps for service
Lordship,
of
1
notice
and
upon.
2.
Petitioner takes steps for service of notice upon respondent number 1
Lordship, 1.
Only respond number 1, my lord.
within 2 days.
Lordship. Lordship.
897 days.
Some maybe. Much less, Lordship.
Main list, item number 1.
Yes, what is this?
CD was called for, my lord.
Yes, Mr. Shulai, do you have the case diary?
Yes, I have the case diary, Lordship.
Can you flag mark those relevant parts so far as this petitioner is concerned?
I have not done that, Your Lordship.
Can you do
But-
it? This will help me.
Yes, Your Lordship. That I'll do. I'll do, but not today.
Just flag mark
Yes,
and then
not
submit it
not
later.
today, Your Lordship.
You will not be filing any affidavit as you
No, no,
submitted
Your Lordship.
earlier.
Because his only relief is for a direction not to take coercive action, Your Lordship.
My
Yes,
lord,
wait for quashing also, I think.
yes, my lord. My prayer is twofold, my lord. Number one, my lord, I am seeking a mandamus, my lord, so that, my lord, my statement can be recorded by the IO and no coercive action may be taken, my lord. Number two, certiorari. So far, my lord, the FIR, my name is concerned, my lord. I have come seeking quashment of the FIR so far as my name is concerned, my lord. Now, with regard to the first part, my lord, I don't know whether, my lord, the prosecution side will raise any objection, because, my lord, my prayer itself is, my lord, limited to the extent that I want to, my lord, help the prosecuting agency to, my lord, do the investigation properly, my lord. I cannot ask for quashment of the entire proceeding, my lord. I cannot ask for quashment of the FIR, my lord. My limited prayer, my lord, I want to cooperate with the investigation, my lord. And, my lord, I want to record my statement so that I can give my inputs, my lord.
What is the scope of a court to give relief in a writ petition, criminal writ petition? It's permissible in law.
My lordship. So far as, my lord, the second part, that certiorari part is concerned, my lord, that I don't know, my lord, because the case diary will reveal as to whether my presence, my role, whether any, my lord, conspiracy theory against me, my lord, has been come out, my lord, because that is why, my lord, CD has been called for to see all those aspects, my lord. My case is very clear, my lord. I have not incited anyone to do any unlawful activity, my lord. I have not, my lord, done anything. I was not present in the place of occurrence at the time of occurrence, my lord. So, my lord, that is why, my lord, with regard to the second part, that the honorable court will see whether my prayer before your lordship, whether it sustains or it doesn't sustain. So far as, my lord, my first prayer is concerned, that is with regard to the mandamus, my lord. That is, my lord, my prayer is, there is a provision, my lord, section Unlawful Activities Prevention Act has been, my lord, put in
That
this.
is why you come by criminal writ. Is
My
it?
lordship, my lordship.
So supposing if a benefit of a legislation has been intentionally taken away,
My lord.
can the writ court reinforce it?
Yes, my lord, there are numerous judgments of the Supreme Court, my lord, as well as various high courts, my lord, which, my lord, has clarified all these aspects, my lord. If this, my lord, unlawful activities would not have had been there, my lord, my lord, limited scope would have been 438 and, my lord, 482, two different petitions, my lord. Now is the situation, my lord, when there is a specific bar under section 438, my lord. Now is a situation when even if I am granted some liberty, my lord, some protection in the interim stage and in the main stage, my lord, if my petition goes, my lord. So the question will then also come, my lord, whether my interim prayer will remain or not. And that is why, my lord, my first prayer with regard to, my lordship will see whether my first prayer with regard to mandamus for recording statement and, my lord, no coercive action will sustain or it will not.
That is your main prayer basically.
My lordship.
Once you say that you are ready to go and give your statement,
My Lordship.
that your prayer for quashing the FIR would not come, at least at this stage.
My Lordship, because my Lord, my statement is necessary to ascertain, my Lord, whether my role is anywhere involved in this particular case. Because now is a situation, my Lord, wherein investigation is proceeding in assumptions and presumptions. Because they have neither taken my statement, nor, my Lord, I don't know whether anything has been, my Lord.
That CD will reveal.
Yes, my
definitely
Lordship.
what's there. So, is anything would remain? We will dispose this matter, isn't it? You right now,
My Lordship.
without considering any interim prayer,
My Lordship.
since Mr. Shulai has made a submission
My Lordship.
that state would not file any affidavit, we can finally dispose of the matter.
My Lord, this is a writ petition criminal, my Lord.
Lordship,
Writ 482.
if he insists on for quashing, then to that part, your Lordship will need to file the affidavit, your Lordship.
No, but then
but
he's not,
so far
not
the
insisting. He's not
relief,
insisting. He said that he is ready to go and
so far
give
the
his
relief claim in the relief number 1, your Lordship. In my humble and respectful submission, your Lordship, this is a part. This is the part and parcel of the statutory duty of the police, your Lordship. A writ petitioner has no business, your Lordship, to dictate the police. You should take my statement. That is for the police to, Lordship.
No,
the law will take its own course, your
But
Lordship.
then
He cannot.
he expressed his willingness that if in case it
For
is
that,
required,
for
he
that,
will
if
volunteer
he's,
for it.
then your Lordship, he has to surrender. He has to surrender before the police,
He
your
is not
Lordship.
going and forcing the police to get his statement recorded.
He has
What
to
says,
surrender, your
he only
Lordship.
volunteers.
Because Lordship kindly see, Lordship kindly see the FIR. The FIR reveals that he's the accused number 1, your Lordship. So for that, your Lordship, he need to surrender before the police, and the police will accordingly take his statement in accordance with the provision of 161, 162 CRPC, your Lordship.
Anyway, you please submit the CD. This we will dispose of the matter, whatever you think.
My Lord, this is not a 438 application. I have already, my Lord, submitted, my Lord. So, my Lord, if I don't know, my Lord, because
Then another aspect also, your Lordship, another aspect.
No, what would remain then in such a case? You see, here relief is confined to the quashing of the FIR and also grant of protection to you.
my Lord.
So these are the main things. If you want that court should deal with the interim prayer, we can do it. But then since you are not very much pressing the prayer for quashing the thing, I don't think there is, keeping this matter pending would be useless. It's up to you if you want.
My Lord, at the very inception, the FIR, the allegations in the FIR, and all the relevant materials available at present, my Lord, that I have annexed in my petition, my Lord, does not remotely indicate, my Lord, my involvement,
That is
my
your
Lord.
submission. We understand, but then we have
And-
to appreciate it after we go to the CD
Yes,
stage.
my Lord. And I am not entitled to see the case diary, my Lord.
Then now you know
Anyways.
that the settled law
So, my
with
Lord,
regard to the
yes,
quashing of FIR.
yes, my Lord. So, my Lord, if there is nothing, my Lord, so there are numerous judgments, my Lord, which says, my Lord, if there is this particular petition, my Lord, under what circumstances, why my name has been put, my Lord. If only it has been put because of the fact that I am a party to a particular, my Lord, member of a particular party, my Lord. Under that circumstances, that is why, my Lord, in a writ petition, my Lord, the state should file their affidavit stating, my Lord, the grounds as to why they are, my Lord, opposing my prayer, my Lord.
If they decline, can we insist that some affidavit has to
Lordship,
come?
Then benefit will come to me, my Lord.
Is going on,
Obviously.
your Lordship.
If
The
they
investigation is going on, your
But
Lordship.
then, if for against the prayer of quashing, they are ready to file an affidavit. In such a case, we will issue notice and then allow them to file this thing. And meanwhile, I'll just go through the CD and pass interim order.
My Lordship. So, with regard to, my Lord, second part of my prayer, my Lord, let them file their affidavit. With regard to first part, my Lord, I pray, my Lord, some interim may be allowed, my Lord, so that
We'll just see, yes,
My
you have
Lordship.
made your prayer.
So
My
far
Lordship.
interim protection is concerned, your Lordship. In fact, your Lordship, a coordinate bench of this court, your Lordship, in bail application number.
I cannot come by of a bail application. I already submitted, my lord. There is a specific bar, my lord.
Let him go. Let him go.
My lordship.
These are all anticipatory bail applications.
Lordship, yes. If Lordship kindly see paragraph paragraph 17, Your Lordship. At page 6.
Yes.
Lordship, this is the fact, the finding of the Honorable Court. Then, Lordship, I kindly see para 18. From the content of the case, it is found that the involvement of the patient has been referred by some witnesses. However, to exact the argument, the IU has not been able to detail. But considering the fact that the nature of the offence is serious and grave at this juncture, the court cannot interfere with the proceeding of the investigation. Given the fact that Section 13 of the has been included in the case with so and so, the application under referred have to be concerned in the light of so it would to bring out so and so. Then Lordship kindly come to
Oh, it has been held. The application is not maintainable.
not maintainable, but Lordship, the merit, the learned court also has gone into the case diary and found that something is there, Your Lordship. Something is there against the petitioner. So in that view also, Your Lordship, this
Petitioner in those cases.
yes, Your Lordship, this bail application has been rejected not only on the ground of maintainability but also on
merits.
on merits, Your Lordship.
So you just kindly flag mark those relevant parts
Lordship.
and please submit the CD.
Yes, I'll do that.
We'll pass order.
So far as, my lord, interim prayer is concerned, my lord, my only prayer, my lord, the basic principle of, my lord, criminal jurisprudence, that is, my lord, the, my lord, presumption of innocence, my lord, and that is why, my lord, I have come, my lord, that part, my
It
lord.
is at the stage of investigation.
Yes, my lord.
So that's what. Anyway, we'll just see.
My lordship.
We'll go through the CD and then.
My lordship.
And you submit the CD and then we'll pass.
Lordship, I'll do the apply.
Send it to my chamber.
May I pray for a specific date, my lord, so that because, my lord, I come from Guwahati, my lord.
See, how long you'll take to file affidavit, Mr. Sulai?
Lordship, it will be 2 weeks only, but right now is pressing for that.
See, date will be given. Why don't you verify it later and come accordingly?
My lordship.
Your colleagues are.
My lordship. Only, my lord, the second part is, my lord, they'll file an affidavit. Quashment, not the entire investigation, I cannot ask, my lord. Only so far as my involvement is there, my lord.
You do one thing, the first part, okay? Hard landed counsel for so and so, so and so. You should notice. Returnable in 2 weeks. Mr. Andy Shulai has appeared for all the respondents. Mr. Andy
All the
Shulai appears
respondents.
Lordship, all the respondent, Lordship.
such.
PP.
No notice, no formal notice is called for. That will be the first part of the order. Then we will come to the hard also the learned counsels on the interim prayer. Okay. Then we'll continue that part.
My lordship.
And then whatever the subject to CD and all, let us.
Lordship, so far that coercive action not to be taken, Your Lordship, I would still rely on the decision of the Honorable Supreme Court, Your Lordship, in 2021, the copy which has already
Niharika
been.
infrastructures.
Lordship, Niharika infrastructure, Your Lordship.
Which paragraph you precisely
paragraph, it starts from paragraph 49 to 72, Your Lordship, 71, Your Lordship, and then from 72 to 80, Your Lordship.
Paragraph 49.
Paragraph 49 to 71, then from 72 to 80, Your Lordship.
And my judgments I already placed, my lord. Arnab Goswami
One is
Mehta
Arnab Goswami case
and
another-
Hema Mishra, my lord. That was, my lord, under you, my lord, Uttar Pradesh, my lord, wherein, my lord, 438 has been, my lord, deleted. And my case, my lord, UAPA Act, my lord, there is a specific bar, my lord. More or less, my lord.
The
Same
benefit of
situation.
438 is not available to you.
Absolutely, my lord. Deeply obliged, my lord.
Apply, your lord.
Item number 2.
2 to 6.
May it please your lordship.
Yes.
Lordship, this is an application under section 482 CRPC, my lord.
Again, POXO.
No, my lord. Here is the section level against the accused person, my lord. Is against petitioner is 354, my lord. 354, 341, 323, my lord. Here, my lord, I have made the complainant as a party, my lord. The complainant has not approached, has not come before this honorable court, despite notice being served upon the. So at this juncture, my lord, I'm just praying that the ex parte order may be proceeded against the complainant, because as it is, my lord, settlement has been reached between the complainant and the petitioner, my lord.
Where is that settlement?
Settlement, my lord, the first settlement, my lord.
This complainant has been served.
Lordship, it has been served, my lord. I've submitted. I filed an affidavit to that effect also, my lord. Bring on status report, my lord. It's annexure 1, my lord.
1 second. Just let us verify your service. Where is the affidavit of service?
Service. One second, affidavit service, sir.
Any other file? This one?
Affidavit service. My lord, was served on 23rd, my lord. Filed on 23rd.
This is the correct address. Is it the correct address?
My lord, it is, my lord.
I am come to the FIR. What is the FIR?
FIR is at page. It's page 14, my lord. Annexure 2.
See, at the bottom of the thing, 2 addresses are given. 2 addresses of the.
Lordship, the complaint is no longer staying in that present address anymore, my lord. She stayed there earlier, but she's no longer staying in that present address, my lord. She's actually a permanent resident of Tura, my lord.
Okay. If you say we'll proceed, but then it says he's at present residing so and so. So that is what the problem is.
Lordship, she was residing in that particular place, my lord, because she actually came for some sort of settlement in respect of one particular land, my lord, an acre, wherein the dispute arose, my lord.
The concern of the case is that the court of the is that that it should not be.
Lordship, if lordship requires, then I can take steps for this address as well, also, my lord. Lordship requires.
Mr. Shulai.
Lordship.
See, FIRs.
Lordship, kindly come to page 15.
Yes.
Lordship, kindly see. There are two addresses.
That is what.
Then Lordship, kindly come to page 39. That is the statement recorded by the police under 161.
Page 39.
Page 39. Same address as in the FIR, in that first address. Then Lordship, kindly come to page 48. 440. That is the agreement, Your Lordship. Kindly see the address. The address is different from the one given in the FIR and also in the statement under 161, Your Lordship.
Lordship requires I can take another steps, my lord.
Lordship, it would be fair, in my humble and respectful submission, if dusty service can be.
No, whatever way, but then you should take steps.
Lordship.
Lordship.
Though an affidavit of service has been filed in this matter, the private respondent has not entered appearance. Perusal of the case record shows that the private respondent has more than one address of resident. In such a situation, it would be appropriate for the petitioner
Lordship.
to take fresh steps
Lordship.
with regard to service of notice upon respondent number 2 on the different address or on the address
Presently citing, my lord.
Where she is staying presently, Your Lordship.
just what last time.
Presently citing.
It would be wise for the petitioner to verify the actual address of the respondent number 2 and take fresh steps accordingly.
Lordship, if I can take steps for this address, my lord, because as per my instruction, my lord.
Verify it. That is what you see. You can contact your client and get fresh set of instructions.
Lordship.
That would be better.
Lordship, rather than taking the steps for.
See, like you taking the steps in the same address again, for which you have already filed a service, affidavit of service.
So, Lordship, I understand, my lord. But she's no longer staying in that address as well, my lord. The second.
You verified.
Try to verify.
Yeah. Lordship. Lordship will verify it, my lord.
Again, read me the last. Within 2 days?
Within 2 days, my lord.
Within 3 days?
2 days, my lord.
This matter again after
2 weeks, Your Lordship.
2 weeks.
2 to 6, Your Lordship. These are
Similar matter, my lord.
similar matters. Apply, Your Lordship.
Item number 7.
This is an Okkama matter, the petitioner is not here. This matter was heard in length.
Who is
Mr. Hazarika, Mr. Hazarika.
May I please, Your Lord?
Yes.
This matter may be come up after a week, my Lord, because I will not be in a position to make argument. Always coughing and this and that, my Lord.
You are not well?
Yes, my Lord. Cold and cough, my Lord.
No objection is this health issue.
After a week, my Lord.
Mr. H. Hazarika.
This was the matter was fixed for written argument, but my lord has to hear it again.
Yes, there is no other option because it has not been kept as part heard.
Yes.
Mr. H. Hazarika, Lord at Counsel, appearing for the petitioner 6. For the time in the matter, on the ground that he is not well. Stop. The prayer has not been opposed by Mr. Day, Learned Counsel for the respondent. Take 2 weeks, I think.
Yes,
List this matter after 2 weeks.
Item number 8.
May it please your Lordship. Lordship, I'm appearing on behalf of the petitioner in this matter. Lordship, I'm seeking for some accommodation. Senior counsel is leading us in this matter, Lordship, but he's having personal difficulties attending court today.
See, madam, these are 2017 matters.
Lordship.
What is the case about?
Removal of signboards on the national highway roads.
It's a writ petition of 2017.
Yes.
Any cause of action survives till now? What would happen?
We have complying with the Supreme Court's committee orders, and in compliance of that only we have removed certain number of signboards, and aggrieved by that action they have come by way of writ petition to establish their right. Under what authority of law they have established those signboards also is not known. What is the source of power? Only, but insofar as our action is concerned, my lord, we are complying with the Supreme Court's order. That is the limited.
Lordship, if I may respectfully submit, the Supreme Court order stipulating the removal of hoardings as well as signages from highways as well as national highways and state highways, the state of Meghalaya and state of Sikkim have been exempted to a certain extent, Lordship. So, and with regard to the tax payment, which the advertising agencies pay for putting up signages as well as hoardings, that issue is still not yet decided, Lordship. There is some loophole when it comes to which government agency actually takes care of the tax and maintains the tax, Lordship, because the tax we pay is to the municipal, but the state is still not clear as to who maintains the records of those taxes, Lordship.
And who gives the permissions also? The law is
on
not.
what basis they
have established all those signboards. The law is not clear on that also.
Somebody must have permitted them.
In the writ petitioners writ petition, the annexures, only certain money receipts and all are there, but then under what provision of law? Of course, that is not the issue raised.
You have accepted the money. That will be for
the
you.
Different agencies, the municipal, the PWD, and every other agencies, whoever has been approached, it seems the association members have been allowed to erect one and every signboards, every nook and corner. Nobody was regulating it. So rightly, we have complied with the Supreme Court's order, and I don't see there is any illegality.
Supreme Court order so far the removal is concerned.
Yes, my lord. At that point of time,
acceptance of money on their, have you returned their money?
My lord, that has never been raised in any issue, and we have not answered to any of such pleadings, my lord. And that is not a pleaded case of the writ petition also, but nonetheless, my lord, this is also an issue which needs to be kept in mind when we are dealing with the signboards and their existence and how they are set up and how are to be regulated.
So
next week, after 2 weeks, my lord.
There are how many members in your association?
Lordship, I do not have the current number, Lordship, of agencies.
No, at the time of filing of the writ petition, how many were there?
Lordship, there are 2 petitioners, but the agency overall, the constitution...
As an association, isn't it?
Lordship, yes. But it's represented by petitioner number 2, Lordship, but the exact number of agencies...
Your association has how many members?
Lordship, I'll have to verify the number, Lordship.
It's not stated in the petition?
No.
No, Lordship.
How many have been allotted the permission to erect advertisement hoardings and all?
Lordship, I'll...
Because I am sure at some time or the other, if any judgment is to be passed, everything has to be discussed, my lord. So whether we have, it is a fact that we have not replied anything on that aspect, but then when my lord will be adjudicating, my lord will also see different aspects of the matter.
Lordship, if you come to page 19 of the writ petition, Lordship, there are 12 members of the Advertising Association.
These are signatures.
Lordship,
Where's the name? This is signature appended to the authorization. So only some of but the people, those who were present, they signed it. It doesn't show the number of members of the association. How a court will pass a blanket order?
And in the annexures also, my lord, the permissions and all are given. Some are from the executive engineer PWD. In some pages, the money received is received by the municipal board. My lord, so much of confusion, my lord.
That will be for you to clarify. How do you allow so many authorities to collect money? If they collect money, they are answerable.
But they have not pleaded any such, so we have not replied particularly on this issue also. Only thing how we are compliant.
Yourself you are raising that, and you say that they have not paid it to proper authority. If that be the contention, then you have to say why, how those people have received this money, under what authority. Once you get permission,
Lordship.
does it mean it will continue for lifetime? Is it something like that?
No, Lordship. We are given permission and it's renewed periodically.
Periodical permission.
Lordship.
Now, you have come on behalf of an association. Now, how many were having valid permission at the time when those removal orders were passed?
Lordship, as per our contentions, all of the members of the association had valid permissions.
All means how many? Where are those? Can you substantiate it? You have enclosed some payment receipts and all. But then what about the duration of this?
1 year, in terms of the permission is 1 year, valid for 1 year.
So 1 year from which date?
Kindly have page 24 onwards. So this is a permission of 2013, 16th of April 2013.
24.
See a para 10, page 24, para 10. Valid for 1 year.
Yes, from 16/4.
Yes.
So it is gone. The time when it was not basically subsisting at the time when those removal was made.
But Lordship, we had made advance payment of tax to the authorities in the year 2017 and 2018.
See, this is a permission granted to one individual. The page which Mr. Nongri has referred.
Then, my lord, we have page 27 from another person.
Okay, so it seems this person's license had expired at the time, and then
page 28 is for 2 calendar years.
See again this page 27. Who is Brain Jam? Brain Jam Communication speaks about some other business advertising agency. The permission is dated 31/10/2007 and it is for 1 year. Now, if your association members are not similarly situated, how an association can advance their cause?
Lordship, I'm praying if this matter may be listed next week, I'll bring on record the exact numbers or exact names of the members of the association, as well as the permissions that were given to them.
See, different. See, this brain jam has been again permitted in 2013, and then it was for 2 years. That also expired in 2015. No, I think your members are not similarly situated. So anyway, Mr. Nangri, what to do? Asking for.
Mr. Paul come, Lord, I think he best person to explain his case.
Yes. That's prayed for by learned counsel for the petitioner. This is matter after 2 weeks.
2 weeks.
Highly obliged, Lordship.
Please clarify those points. These are otherwise it will create confusion.
Item number 9.
This is also pending for written argument. What is that matter?
My lord, matter is with regards to
You
the.
have filed your written argument in this matter?
No, my lord.
The last order says that. It was on 31/7.
I have not.
Yes, it was also hard. This matter also was also hard.
I recorded.
Yes.
My lord, this is a second round of litigation, my lord, by the petitioner, my lord.
Ready?
Lordship, the learned DSCI is on legs.
That is a medical categorization case. The other day you are good.
My lord.
Mr. Mujika was supposed to place some documents on record, I think, with regard to the proceeding of medical.
My lord, yeah, that is in a different, my lord. That
Not
is-
this matter.
Not, my lord. That was in a case of. That is also one medical categorization and invalidation rule.
Dismissal against dismissal. Or rather, what do you say? Termination.
Discharge.
Discharge.
In 2017 also impugned order was passed whereby they have recalled it.
The other day also the allegation was that alcohol withdrawal.
ADS.
Same.
Same. my lord. Now the ADS has become a weapon for the Assam Rifle, my lord.
All your clients have the same background.
My lord, it has become a weapon, my lord. Here, glaring is that, my lord, in the year 2017, one order, my lord. In 2017 also, they issue the, my lord, can come to page 111, my lord.
One.
Yes, my lord.
Just let
Sorry,
me just get the facts.
Sorry.
Yes. There was a case before also.
Before, my lord, if I take
that is challenging your same thing, discharge.
Discharge, my lord.
Then
And that was cancelled, my lord, by themselves, my lord. My lord can come to page 111, my lord. Annex 9.
$111.
11, my lord.
And on that basis, your writ petition was closed.
Closed, my lord.
What is the order passed by writ court?
My lord, 112, my lord.
So court disposed of by taking into consideration that order of withdrawal.
Yes, my lord. Fresh invalidation board, my lord. Suddenly, my lord, they pass an impugned order, my lord.
Now, the fresh invalidation medical board was not constituted thereafter.
No. No, my lord.
Correct, huh?
On the strength, my lord, in the entire affidavit, after 2018 when the order was passed, my lord. Nothing, no fresh. They relied on the previous medical board, my lord.
Yes, ma'am. What is then? Issue is confined to. Can be confined to that only.
Definitely, my lord.
Without going into other aspects.
On the merit.
For the time being, subject to what they say. Now, if your earlier withdrawal order was for the purpose of a fresh IMB proceeding.
IMB proceeding.
And without doing that, how do you again discharge him?
Lordship, Lordship, para 2 of our affidavit in opposition, Lordship. Para 2E, page number 4, Lordship.
Page 4.
Page number 4, para 2E, Lordship.
This is affidavit filed by Deputy Commandant.
Yes, Lordship.
Para 2H, page 3.
Page 4, Lordship, of our affidavit in opposition, filed by Directorate General Assam Rifles.
How many affidavit in opposition are there? There is only one affidavit in opposition.
Lordship, this was filed on 31st July 2018.
Yes. I, Deputy Commandant Uttam Singh. Is it that?
Lordship.
Yes. You are referring to para
2E.
2E. At page?
Page number 4, Lordship.
Page number 4 has C, D up to D, not E is not there. E is at page 5.
Lordship, some error with the pagination, Lordship, I think. Lordship, I would like to refer to paragraph 2E, Lordship, of our affidavit in opposition. Lordship, in this para, that as the petitioner was placed in no medical category S5 by the psychiatrist with effect from 10/4/2017, the petitioner was liable to be invalidated out of service. Therefore, fresh invalidation medical board was conveyed. Fresh invalidation. Fresh invalidation.
No, Mr. Mujika, right now issue is confined only to the issue of only to the issuance of the letter annexed at page 111 of the writ petition and subsequent passing of the order by the High Court at page 112. Just please these two pages, because these were the things which are referred by Mr. Jha.
But
Now
what
this-
happened, my lord? Earlier, invalidating medical board was conducted, and because of his S5, my lord, he was boarded out of service. But there was some problem in the convening order, my lord. There was a reference to a different convening order at that point of time, my lord. May I just point out that, my lord?
But then you see your letter,
Cancel,
the last line of your letter. The conduct a fresh IMB proceeding.
My lord. So fresh IMB is to be conducted, my lord.
Yes.
After that, the writ petition on that basis was closed, my lord.
Yes.
And fresh IMB was conducted after that.
That is what this is, no. That is what the submission of the Runner Council. So we thought, why to go into other issues? We can finish it on the basis. Now, where is that fresh sort of IMB?
My lord.
See, Mr. Jha, at least I think if you place the correct position, that things become easier. We do not have to
My lord,
dwell on issues which are not required at least.
definitely, my lord. That's also.
But page 27 of my counter affidavit.
27. Yes.
This is of 27 February 28, my lord, on the top right hand corner.
17 February 2018.
27 February 2018.
17th, 17.
So it's mentioned 27 here, my lord. Page 27.
Yes, Annexure 6.
Annexure 6.
My lord, that is the convening order of 17th February.
Okay.
And the date of proceedings, my lord, is 27 February on the right hand corner, my lord.
Okay. 27th February, yes. But then this is before the High Court passed that order.
Yes, my lord.
High Court order
March.
14/3/2018.
March.
14/3/2018.
Yes, my lord. My lord, High Court has not passed any order. My lord, High
My
Court
lord.
only said, my lord, your lordship kindly see. High Court only recorded that there survives nothing in the writ petition bearing number so and so.
Because of the issuance of that order.
My lord.
It
That
was
signal,
placed
my
before the
lord.
High Court.
That signal is also quoted, my lord.
And that signal also says that IMB should be convened afresh, my lord.
See, Mr. Jha, there is one point. That letter is of January.
My lord.
That letter, basing on which your writ petition was closed,
My lord.
it was dated January. That means the proceeding which Mr. Mozika is referring right now is after that only.
My lord. My lord, that is of January, my lord.
Yes.
Uh,
So it means after that. If that be the thing, then you have nothing, no case then.
My lord.
At least on that ground.
My lord, 109. If it is in January, my lord, the case was pending, my lord. Page 109. This is the affidavit filed by them, my lord. 21st day of February 2018, my lord. Where this letter was annexed.
I could not follow. This court could not follow what you say.
My lord, the later, my lord, annexure 9.
You are referring to their affidavit.
No, my lord. No, my lord. My writ petition, my lord. My writ petition.
Yes, your writ
Page,
petition.
annexure 9, page 108.
Yes, they.
My lord, this is an affidavit filed by the respondent authorities.
In that earlier round of litigation.
Earlier round of litigation. That was on 21st February 2018, my lord.
Yes.
Thereafter, the Honorable High Court has passed the.
Okay, this is dated 21st.
February 2018.
Something is wrong.
Thereafter, the High Court has passed the order.
Something is wrong.
And my lord, page 26 of their affidavit, my lord. 26 of their affidavit, my lord.
These are some glaring points, Mr. Mazika. I do not know you.
My
How
lord,
you will clarify all this? You are referring to a medical board which assembled on 27
February 2018, my lord.
The convening order itself says, my lord, 17th February
Then
18.
order is of 17/2.
February.
You filed the affidavit on 21st February. Nothing has been mentioned.
My lord, the purport of order. My lord, what was challenged was the previous invalidation, my lord, by him in the writ petition. We came and submitted before this honorable court that has been recalled with a direction to start fresh invalidation medical board, IMB, my lord. And that was brought to the notice of this honorable court, and this honorable court closed the matter that what was challenged has already been recalled.
In this year, there should have been a mention in your affidavit.
That was a discharge order, my lord.
But my lord, the
September
affidavit
16,
was filed on 22nd of February, lordship kindly see.
It was signed on 21st February.
It was signed on 21st February, my lord. And the next board was on 27th after that, my lord. Next board was on 27th of February.
But then it was convened before that, 17th.
It was convened before that.
There is no mention about that. Now, if you had convened, why you did not disclose it to the court?
To the court that we will, that writ petition would have been a pending, my lord.
Is it only an omission or it is something
grave, man? My lord, the page 26, if I take, my lord, so page 26 of their affidavit, the convening order, the purported convening order, my lord. A fresh board of officers composed of such and such time and date fixed to carry out IMB in respect of such and such, who is a case of ADS relapsed individual recommended to be placed under low medical.
You are reading page 26, Mr.
26, my lord, 26.
Which part you are reading?
My lord, from the beginning only, my lord.
Yes.
My lord, S medical category S5 and invalidated out of service by psychiatric ARS CH Sukobi Bhide opinion dated 10th April 2017, my lord. 10th April 17, my lord. Invalidated out by a the very purpose of convening order, my lord.
It went by the earlier report.
Earlier. Based on the earlier, it's a malified, my lord.
They set only for the purpose of endorsing that earlier.
Endorsing the previous.
He's S5, my lord, already.
Irrespective of my lord, I may
No,
be
but then if you convene a new board,
my lord,
they should do their duty. It is not that only they put their seal of approval.
My lord, it's not that, my lord. They've examined, my lord, page 27 onwards is the proceedings, my lord. His statement was, he was questioned, my lord. He has put his signature in the next IMB, my lord.
All, my lord, page annexure 7, page 27, the all 2017, 16, 17, my lord. My lord can come to page 34 of their affidavit, my lord. This is a opinion based on 2017, my lord, 30th September 2016.
Opinion of 10th April 17, my lord.
16.
17, my lord, 10th April 17. Now, how is submitting?
You are referring to page
34, my lord.
This is 30th September 2016.
16, my lord. That's why, my lord, at the initial stage, I have said that now ADS has become...
Facts are not placed correctly, my lord. I'll just give 3 dates, my lord. Yes. Only 3 dates, my lord. My lord, 39/2016 is the first date, my lord.
One second, Mr.
September 2006, my lord. 2016, first date. 30th November, 39/2016, my lord.
Yes.
30/9/16. First time he was placed under S3, my lord, for 6 months.
2017, isn't it?
16,
16, sorry.
30 September 2016.
Is S3.
S3, my lord, temporary. For 24 weeks. T24 means a temporary 24, my lord. Temporarily downgraded for 24.
2 months.
My lord, so next review was due after 6 months, my lord. So that will come in the month of March.
No, this is at which page? This
my lord. 34 of the affidavit, my lord.
page 34 of the affidavit.
My lord.
Not 34, my lord. Your lordship will get that at page 27, my lord, of my affidavit. 34 is something else. Page 27, my lord, at the bottom, my lord, on the right hand side, 3 dates are there, my lord. S3, 30th September 2016. Then again S3, 27 January 2017.
Yes.
So, my lord, what happened when he was downgraded to S3 in September 2016, my lord? So he was due for next review after 6 months, my lord, as per the rules. But before and the 6 months will fall in the month of March 2017, my lord. From September,
yes,
October, November, 6 months will be sometime around March. But before that, my lord, on 17th January 2017, that is the important date, my lord, that is mentioned here also, he again fell down, my lord. And in unconscious state, he was brought to hospital, my lord. And that was a case of relapse. So, my lord, on 27 January, he was again declared to be S3, my lord. Then, my lord, what happens? His next medical was due on 14th July 2017, my lord. 14/7/2017. But again, before that, my lord, he again relapses, my lord. He was brought to hospital in unconscious state with injury in his chin on 28/3/2017. May I point out from the affidavit, my lord, the statements in the affidavit, my lord. He did not complete both the terms, my lord. Even before the terms, he collapsed, my lord.
We'll refer to which paragraph?
My lord, in my affidavit at page 2, sub-para A, B, my lord. A and B, my lord. May I read?
The last occasion he did not collapse, he was unconscious. No, he was intoxicated.
But he was brought in unconscious state, my lord.
He's intoxicated and unconscious. It is not that he collapsed.
Those were, my lord, of 2000 that led to discharge order, my lord, which was subject matter of the earlier round of litigation, my lord. That was a discharge order, my lord, which the petitioner was served, and then we have challenged, and that was set aside. That was of 2018, 8 September 2017, my lord.
And that was not set aside. This writ petition was closed as infructuous.
That was cancelled by them, my lord.
Yes, they recalled that order.
They recalled that order. That means.
So these are all incidences before.
Before that, 17. Now we are in 2018, my lord.
Same incidents, my lord. Only because of some technical glitch in that convening order, my lord. A fresh convening order was issued and the same S3.
And the purpose for which,
my lord,
you cancelled that is not reflected in the thing. But then it was good enough to close that earlier round of litigation. You did not say that you do basically just for the purpose of correcting some clerical error or technical error.
My lord, in subpara C, my lord, there's some reference to that, my lord, of my affidavit.
It doesn't say, it's nothing, it's only.
Subpara C and it goes on, my lord, subpara D also.
What did you say in your earlier affidavit?
Subpara D said, my lord, that when the writ petition.
Just a minute. We're just talking about the affidavit which you had filed in the earlier round of litigation.
But
that may be called, my lord.
Well, it will throw some light on for what reason the earlier discharge order was recalled, my lord. Subpara D.
It's nothing, a simple statement. They have this thing. Cancel the impugned discharge order earlier. See? See paragraph 3, what it says in that earlier paragraph, earlier affidavit. It says, in the view of the fact that the impugned order under challenge before this honorable court has been cancelled by the respondents and the grievance of the petitioner have been addressed resultantly. That is what. Nothing survives. Now you say you address all the grievances, and that is stated in the affidavit before the court. See, come to page 109 of the writ petition. See paragraph 3.
Well.
Read paragraph 2 and 3, page 109.
Thereafter, the respondent authority via DGR signal number so and so dated 25th January 2018 has cancelled the impugned discharge release order number so and so, which is under challenge in the instant writ petition. That in view of the fact that the impugned order under challenge before this honorable court has been cancelled by the respondent, the grievance of the petitioner having been addressed resultantly, nothing survives in the writ petition for adjudication by this honorable.
So you have this thing. You have said this thing. Redress all the grievances.
My lord,
no, that what it, see, we will not give any other interpretation than what has been conveyed by that.
My lord.
At least I don't think like you can say that it was. See, you said that his grievances have been redressed.
My lord, the document that has been annexed, which is the exact recalling order, my lord, that is at page 111, my lord.
Yes.
This is in the military language, but still I'll try to read, my lord. Discharge release from service on medical ground, reference HQDGR UPA letter number so and so, size so and so. Discharge release from service on medical ground in respect of GW so and so, size UPB approved with effect from 1st January 2018. Where this department order number so and so is hereby cancelled. Request take action as per letter under reference and conduct a fresh IMB proceedings. For info.
That means all those earlier actions come to an end. The fresh, you will take a fresh action.
Finish.
Dependent on the new IMB proceeding.
My lord, may I just refer to para D of my affidavit, my lord. Page 3.
Yes.
I just read that when the writ petition being WPC number 330 of 27 was finally heard.
You are reading at
Page 3 of my affidavit, my lord, at the bottom, subpara D, my lord. Last three lines of page 3. Mistake.
this paragraph D. Yes.
That when the writ petition being WPC number so and so was finally heard, it was observed that the petitioner's invalidation medical board was conducted on the basis of ARCH convening order number so and so, dated 26/5/17, which was already cancelled, and a fresh convening order was issued by letter number so and so, dated 6/7/27. However, in the invalidation medical board proceedings, convening order dated 26/5/17 was mentioned as authority instead of convening order dated 6/7/2017, which was not in order, being a procedural lapse, and the same was not sustainable.
Then, in that view of what happens to your earlier paragraph, where you said that you have redressed all the grievances of the
grievances and then.
My lord, redressed to the extent. My lord, what was under challenge was
he had no grievance with regard to all those things. His grievance was something else.
His grievance was with regard to discharge order, my lord. Discharge order was recalled, my lord.
This is just an improvement of what you did. See, you are basically trying to cover up your misdeeds. You have done it in one way, you see, like just to escape from the passing of order by the court, adverse order by the court. You do it then, and now you come with the improved version. That is what the natural interpretation. Why these explanations were not there?
If I may submit, my lord, there are stages to invalidation medical board, S3, S5, my lord. Then finally invalidation medical board will come. Now there is no problem with S3 and S5, my lord. Only invalidation medical board, because invalidation medical board has to be convened by a higher authority, my lord. So invalidation medical board sat, my lord, but while giving authority, as I pointed out, my lord, there in one page there was 17th January was the convening order, my lord, and the board sat on 27th February, my lord.
That is because of the situation.
Just while referring to the convening order, my lord, there was some mistake in that, my lord.
I can understand that,
my lord.
Your explanation, what you were giving here,
my lord.
But then what about the statement made in the earlier writ petition, where you say that you have taken care of the redressal of the grievances petition. You have redressed the grievances of the petitioner. You have taken care of the grievances of the petitioner. That is what you have said. The plain and flat meaning. Now you are trying to give some other reasoning.
But my lord, the document was annexed with the affidavit, my lord, and the document clearly stated, my lord, the fresh invalidating medical board should be started. That
fresh
is very
medical
categorical
board.
in that.
Yes. That is the
only fresh invalidating medical board, my lord, not as a fresh S3 or S5, my lord. The diagnosis which has been done, my lord, in my humble submission, that will not require to be done again, my lord.
Now, how many types of medical board you have? You have invalidating medical board, and then what else?
One is review medical board, my lord. Review medical board is only for categorize, seeing his condition, my lord, and categorize him, say S1, S2, the P1, P2.
So that is the first. This is the review medical board,
my lord,
which fixes the category,
my lord.
And subsequently
invalidating, but if he reaches category 5 in any of the categories, my lord, either psychology or physical or hearing or eye.
So what is the duty of the invalidating
medical board will again assess the reports, my lord.
Then where is that evidence that you have assessed it?
My lord, it is from page.
The manner which you do it,
page 27
is not
onwards.
very fair.
Page 27 onwards.
In view of your earlier affidavit, the actions which were prevailing prior to the disposal of the earlier writ petition would go. Only except the medical categorization of the petitioner, which remained, that would remain.
That is exactly our case, my lord. Only medical categorization remained, my lord. He became S3 twice, my lord, and then S5 he became. That remains, my lord. And we started afresh invalidating medical board on the basis of those three categorization, my lord.
Say, supposing, was it not required on your part to have a review medical board prior to
initial stage,
my lord? Once somebody reaches
if you say all those actions prior to the disposal of the earlier round of writ petition, got merged with your order, passing of the withdrawal of the discharge order, then what happens? Can this kind of interpretation be given?
My lord, in my humble submission, there was no fault with his medical categorization of 30th
No, but then
September
the
16, my
language
lord.
which you have used earlier in earlier round of litigation, we can say that, because you said his grievances were taken care of. That means all your earlier action merges with your last order of withdrawal. And subsequently it is a restart only.
We have to do again S3, S5,
fresh-
medical
fresh-
record reasonable.
That is the normal interpretation.
In my humble submission,
That's
that
why the fresh discharge order was issued, my lord.
fresh discharge order was only issued only because of some technical glitch in it.
That is you are explaining now, but then that explanation was not there. So this explanation we may not accept at this stage. We just see that after the disposal of that earlier round of writ petition, what liberty you had insofar as your action was concerned, your action is concerned. There has to be an element of fairness. You are public authority.
My lord, I understand, my lord. I can follow, my lord, what is going through, lord. My lord, but page 28, your lordship kindly sees the affidavit, my lord. He participated, my lord. His signature is there, my lord.
So it opens up a new dimension again.
Page 28, his signature and the signature of the individual, my lord.
And that is okay. His participation is okay. He is bound to participate.
Definitely, my lord. If not another charge
See, in a medical board, what role the individual will play? He has nothing. He is not an expert. He is
My
not
lord, he
in a
was asked
position.
questions. My lord, he was asked questions, my lord. Lordship kindly see. Did you suffer from disability mentioned in question number 2? Anything like
Page
it
number
before
20?
joining the armed forces?
28.
Page 28, my lord. Give details of any incident during say, your service which you think caused or made your disability worse.
No. These all are typed.
Everywhere he has replied in negative.
Not applicable.
You are referring to his reply, then you should have gone by his reply then.
What is the percentage of disability, my lord, has been assessed? Page 31, my lord.
0.
It's 0% disablement. So where the question of S5 comes, my lord? It's their own documents, my lord.
You are referring to page 30?
Page 31, my lord. My lord,
Yes.
Column.
What significance it has, Mr.
My lord, that is for the purpose of, my lord, what happens, my lord? There are two types of pension, my lord. One is invalid pension and one is disability pension, my lord. If a person, if his service contributes to that disease, my lord, there are many diseases which develop during the course of service, my lord, or it is aggravated by conditions of service, my lord. In that case, he is also entitled to disability pension, my lord. For that purpose, that is determined on the basis of what is the percentage of disability, my lord. My lord, alcohol dependent syndrome cannot be calculated in percentage terms, my lord.
My lord, they are taking in both
Is it disability or not?
both the way. If they are saying that it is my answer, the things which suits them, here not a pensioner, my lord. It's my service, I'm out. Discharge. That's why I say that it's the second round. Now the ADS has become a weapon for the Assam Rifle to oust the Jawans, my lord.
Well, we can't keep alcohol dependent, my lord. My lord, I'll point out he is unfit to hold firearms, my lord. My lord, the rules deal especially with alcohol dependence, my lord. It is there in the writ petition at page 86, my lord. These rules, my lord, are called, my lord, it starts from page 67. This is called Healthcare System in Central Paramilitary Forces. Instructions for medical examination and classification of personnel in the CPMFs.
Rule starts from page 67.
My lord.
And the relevant part is 86.
86, my lord.
Yes, what do you
It
want
says,
to...
my lord, alcohol dependence,
Yes.
heading, my lord. Alcohol dependence and drug abuse are recognized as behavioral psychiatric problems in ICD-10. These are incompatible with service, ethos in armed forces, and all such cases should be invalidated, weeded out of service, unless the patient shows an unequivocal determination to give up use of alcohol drug for good in the shortest time span. There's well laid down procedure for disposal of such patients of alcohol dependence, drug abuse. However, it does not meet the organizational interest of forces where a large number of men are alcohol dependent and still continue to stay. In view of the above following instructions for disposal of alcohol dependence, drug abuse cases may be strictly adhered to. Alcohol dependence, drug abuse cases will be observed in temporary low medical category in S3 T24 initially if showing favorable response to treatment. If during the period of such observation, White 2A, his condition relapses against, he should be placed in S5 and invalidated out of service. So, my lord, 6 months he has to be kept under observation, my lord. But if within that period it relapses, he has to be declared as S5 and invalidated, my lord.
Those had happened prior to the disposal of the earlier round of blood.
Fresh, my lord.
Your case is only confined to that point, or you have some other ground?
On the other ground, that as far as the medical rule is concerned, Assam Rifle medical categorization and invalidation rule, which is still in force, my lord. 17D, rule 17D say that after 2 years, he should be placed before the concerned medical board after lapse of 2 years, my lord.
If you say medical board, it refers to review medical board or invalidation?
My lord, invalidating medical. It does not specify.
Where it is defined, that thing, board part, invalidating and review part. Is there any definition provided of those two medical board?
As far as the board part is.
This is the same rule which you said, isn't it? That page, you are referring to the same rule at 67, at page 67? Is it the same rule?
No, my lord. It's Annex 3, page 28, my lord.
How many sets of rule are there? 67 is... is not, these are a kind of executive instructions, isn't it?
My lord. Executive instructions.
That is in addition to the rules which Mr. Jha was referring right now.
My lord.
Is not rules actually. Mr. Jha, you are referring to?
My lord, I am referring to Annex 3, page 28, my lord. This is a rule called Assam Rifle Medical Examination.
Categorization and
Categorization
invalidation
and
rules. So
invalidation.
that is basically, this is the rule, it should cover this thing.
Definitely.
Cover up the entire thing. The entire issue would be covered under this rule.
Under this.
Yes. So now you refer to, is there any definition of that medical board, those medical boards?
Page 31, my lord, not see. Page 31, my lord. Sorry, page 32, my lord. Rule 9.
Yes.
Medical board for categorization of cadre officers. A medical board for categorization of cadre officers shall be convened when a cadre officer is considered unfit to be in category SEP 1 or when he is to be upgraded from lower medical category whenever a convening authority is of the opinion that a cadre officer is in command is unfit to perform his duties in category SEP 1. And then it says, well, what will be the composition, my lord, on next page? Composition will be presiding officer, clause B.
Number 10 is medical board for
invalidating
medical board. Here composition is slightly different, my lord.
So definitely it will be different only.
But here the chief medical officer or deputy director medical will be the presiding officer, my lord.
So what is 11 then?
Sorry, my lord, small bit. That is for officers, my lord, and this is for personnel, my lord. 11 will apply in this case, my lord. 11 and 12, my lord.
10 is for cadre officer.
Convening authority should be the DIG, my lord.
So here we will be concerned with 11 and 12, not 10, not 10, not 9, 10. 9, 10 is not coming.
No, that is for officers.
That is where you show, see, none of you are prepared, so that is what the problem is.
Well, there are 3 matters with regard to this. All of Mr. Jha.
You got a code who is totally ignorant about this set of facts, so.
Well, in fact, I am also the first time I am full-fledged arguing this matter. The 3 cases of identical, similar nature, my lord. 2 are listed today and 1 was listed yesterday, before yesterday.
Now, if you want me to read and find out the provisions myself, then it will be quite difficult. There is a provision of appeal also.
Yes, it is there.
So you have not preferred any appeal?
My lord, they have not provided. I have made a statement.
They have not provided means?
The copy of all the medical boards so that I can file an appeal under Rule 9 is there, my lord. 13.
Rule 13 is the appeal.
Yes, that is right.
13, my lord.
Now I am reading it myself and finding
No,
out.
my lord, a statement is there with regards parent. My lord, ground, page 16, ground F, my lord.
So far as your categorization prior to the earlier round of litigation is concerned, have you ever filed any appeal? No.
No, my lord. They have, since they have not provided, my lord. Rule 26 of the Assam Rifle rule is also specifically provide that it should be, they should provide the copy along with, to enable the petitioner to file an appeal, my lord.
Now, review medical board, if you see 14, the review medical board comes subsequent to the
Freshman.
invalidate this thing. What do you say? Invalidation medical board. See, come to rule 14 at page 35 of the writ petition. Just see down below on this 14. This is what is confusing. If you see on receipt of any appeal, now 13 refers to appeal, it says appeal under rule 8, officers of personnel under rule 8. Now if you come to rule 8, that is with regard to annual medical board. Very confusing. Until unless you are able to clarify, this code becomes more confused.
Rule 8 talks about annual medical examination.
Of cadre officers only.
Of cadre officers.
Then come to 14. What does it say?
14 says, well, on receipt of the appeal preferred by any cadre officer or personnel under Rule 8.
So here personnel is also come.
Personnel.
Now if you talk about personnel appeal, that's only 13. That is provided in only 13.
But there are some omissions in these rules, madam.
There are omissions, but then it must be clarified. You see, these omissions maybe it is it may not cause any confusion to you, but then for me this code definitely.
I was equally confused.
See, all along after hearing you and all, you say like, and you said that the review medical board basically for categorization, but then here it says review is a different aspect.
My lord, review is generally used, my lord. My lord, that is medical board, my lord, normal medical board. Whenever somebody is reported sick, my lord, he is sent to that medical board. They do categorization. If he's hale and hearty, will be
See,
declared.
apart from having this annual medical examination of the cadets,
that is annual feature, my lord, every year.
For the cadre officers. Now, what about for personnel? Do they have this same thing? I think Mr. Mojika,
that has to be there, my lord, but I can't find in this.
Please, if you clarify those part, at least this court should get which way it is done. who categorizes, when categorizes, and when invalidation takes place.
Now, to that extent, my lord, Rule 8 for the time being may not be relevant because he was not detected.
I'm not confused with Rule 8, my lord. I'm confused with Rule 14. Okay, I'm confused with Rule 14 because 13 speaks about appeal. And then 14 says on receipt of appeal, what the appellate authority should do.
You can ask for a review medical board to reassess the situation.
That is why, so since that term review medical board is used, that is why this court has put a query to you, because earlier your submission was that it's a review medical board which categorizes first and then invalidation medical board comes. That is why the confusion. Please go through the rule, clarify it.
Rule 8 is only talks about officers. Annual medical exams of CAT officers shall be carried out by
Page, my lord, para 37, Rule 37, oh sorry, Rule 17, my lord, page 37, my lord.
Yes, special instructions for medical board, RMO regarding, RMO is what? Review medical board.
Regimental medical officer. Regarding categorization of the JCO oblique OR, my lord.
OR?
Other ranks.
Other ranks. You come under other ranks.
OR. D is, that's what.
review what is again used.
Yes, review medical board.
That is what the technical.
After this regimental medical officer, he examines, then only will be reviewed by RMO on expiration. So he will be first, RMO will be reviewing for which temporary category was awarded and shall take all actions for holding review medical board. So after he reviews, then only he will take action for review board. First review by him and then second review by both board. He will take action for. Person will appear before medical board every 2 years.
2 years.
For review.
After every 2 years review.
Categorization. However, now if somebody is placed under S5, that provision will not come because he will not be retained to service for 2 years. Will it be?
My lord, that's a subject to that finding should be there, my lord. Suddenly S5 putting him under S5 does not mean S3 temporary T24. That change should be there, my lord, in the entire medical board.
Now this has not been done in your case. This
No, madam.
17D.
No, madam. Specific governments grounds I have taken.
In his case, my lord, on both occasions, he was due for review after 6 months, my lord. But before that, he falls sick. He had to be brought to hospital, my lord. Then it is not necessary for us to, once a midterm review has been done, my lord.
That is provided here also.
My lord.
Here also, if you see the second part. However, if the officer in charge of troops, medical feels category of an individual needs further degradation, he will arrange to bring him before a medical board immediately, irrespective of the fact. So that
Before
is
the
what
medical
you say.
board, my lord. Before the medical board, my lord.
Yes, very
not
good.
his own, my lord. He will.
So that is what happened in your case.
Yes, ma'am.
You deteriorated. They took you to medical board, and then you were categorized as S5.
Yes.
Is it?
Yes, my lord. Twice he was
Leaving
categorized as
aside
3,
the earlier round of litigation, my lord. Leaving aside the other.
But that is what the earlier. This is the only problem now. This earlier round of litigation, which way it is to be interpreted. In view of the closure of the case at that point of time with this court, whether it would mean that earlier orders passed would merge.
Because
since they take that, they use that word that they have taken care,
redress the grievances.
they have redressed the grievances of the.
That's why the discharge order was cancelled, my lord.
But my lord, discharge order, while cancelling, in the same breath, my lord, in the same sentence, it says the review invalidation, fresh invalidation.
That is invalidation. My lord. Now invalidation, that is what I ask you, Mr. Mojika, to seek a clarification whether review comes first. So invalidation is after categorization, isn't it? Can there be an invalidation before categorization?
If somebody is categorized 5, my lord, S5 or P5, in this case S5, my lord, he is liable for invalidation immediately after that.
But then categorization has to come before, isn't it?
Yes, categorization has been done, my lord.
So when invalidation medical board sits, there has to be some kind of categorization of the incumbent, my lord, in respect of whom the board would sit, isn't it? Now in such a situation, the question here is that
whether we could have relied on earlier S3 recategorization.
That was the thing. And which you interpret that situation? So review board comes first, or can you get seek clarification on that? If you call your
review
officials,
in that sense, review, there was no requirement of review here, my lord. My lord, on 3 occasions, 13, 9, 16, S3, my lord. 10/1/2017, before 6 months, he was again recategorized as S3. Then 27th February, my lord, he again falls sick. He has been declared as S5, my lord.
but the one thing is that you see in their withdrawal order, they have made it clear that there will be a fresh.
There will be fresh, my lord. There is no doubt, my lord.
And what will be fresh, my lord? Only
My lord, fresh date, when it will be. That earlier it was culminated into discharging a person or imposing a penalty of discharge, my lord. You are not fit for. That goes, my lord. Taking a fresh, my lord. Fresh cause of, show me the fresh cause. Give me the specialist opinion that yes, the petitioner is S5. You cannot. You cannot be a competent to serve this force.
It was something like only sentence was set aside, my lord. That will not mean that all evidence is recorded and everything is set aside.
Sentence was set aside basing on something.
Sentence was set aside on some technical ground, my lord.
This is technical ground so far as you are concerned. But then so far as court is concerned, it is not. Technical ground, you say, in view of your fresh set of statement which you have made in the affidavit of opposition filed before this court.
My lord.
But then the situation which was prevailing at the time of the disposal of the earlier petition, it was quite different. It was played in such a way that this
their own affidavit, my lord.
The grievances of the petitioner, all those grievances were redressed. That is what.
But the documents annexed to that affidavit, my lord, in my understanding, that is to be given witness.
Yes, neither here nor there. Doesn't say anything. It only gives you a liberty to do this fresh IMD.
But only fresh IMB, my lord, not fresh medical categorization.
Okay, but then in fresh IMD means what? It is only for a formality that it will
Only
sit
final
and
hearing, my lord.
approve.
That's why the convening order says that endorsing the, my lord. Right upon 10th April 2017, they replied. That sentence would not have been there, my lord. They had a better case.
It appears, but whoever drafted that affidavit, my lord, maybe there is something. But the real, if lordship looks at the document annexed, my lord, document annexed to the same very affidavit, my lord.
You're talking about the earlier affidavit.
My lord.
It's neither here nor
The
there.
impugned order is cancelled.
It doesn't say so.
Discharge order
But then
is cancelled.
Your statement you made in your affidavit will be considered superior to what this document contains, because a statement before court. When you make a see, Mr. Mojika, I do not have to say to show you the provisions of law in that regard. That is it's not at all confusing. Whatever say in the court, it has superior. It will be considered superior than what your document says in the record. If you today file one affidavit on oath, that will have the superiority. That is the law. I think we'll continue in the second half to get the facts of the case and then. Is that all right? Or some more clarification? But then how you will clarify me that part? Review and.
Review the assessment.
That review medical board and evaluating medical board.
Well, review is used in a normal sense, my lord. It is not exactly review, because whenever somebody comes after 3 months, we call it review, like normally for doctors also.
No, but then review can be a regular thing. Review means there exists certain decision which you review.
My lord,
Review means you take a fresh view of a certain thing.
My lord.
So that is what.
My lord, one review is a statutory kind of review, my lord, that is provided under Rule 13. That is a statute. That is altogether in what I'm trying to submit, my lord. That we go for a doctor, we come back after 3 months. That also we call review. That will not fall in that category, my lord. A statutory review. That is simply.
But then when you go to doctor for the first time, you will not say that you are going for review.
First time will not be review, my lord. But the second time when you go, it can be called.
That is what. That is what the problem is. Your rule is either it is you say like because of me.
Well, the rules are not.
My lack of understanding, it is confusing. Or
well, the rules are not very happily framed, my lord. That is true. It is not very well structured, my lord, the rules.
When this discharge took place? Which year?
2018.
18.
And till 23, it is pending.
My lord, only
1st August 2018, my lord.
Only mitigating factor that he is entitled to pension, my lord, because he is rendered 15 years of service. That will be stated in our affidavit.
This is what did you say?
He is entitled to pension, well, because he is rendered for 15 years of service, so he will be entitled to pension as per the rules.
About 60 years is a.
Pension is okay, but then we are
on the discharge, my lord.
The legality of an action is under challenge. That is what the problem is. Where are you now, Mr. Rizal?
My lord,
Still dependent on alcohol, no?
no. My lord, he is in service.
Hmm?
Due to stay, my lord, he is continuing the service.
There is a stay order in this matter.
Yes.
Stay order. Very interesting. Where is the stay order? Order shows.
I do not think that is correct. My lord.
No, there is the application. What is the order? Yes, there is a interim order on 31/7/2018, and it seems it's continuing, though it was for till the next date, I think. But then, if he is continuing service, Mr.
If
Majika,
continuing that
He is in
in,
service, my lord.
in continuing in that case, my lord, we can
See,
we can review this S3 S5
definitely that is what you should do. If a person can continue for such a long time,
such a long time, then this become infructuous in fact.
then why don't yes definitely if you then why don't you take instruction? Then if you can do it, then we can close that matter.
I'll have it stop because this fact was not known to me.
Should have pointed
If
out
I-
to improvement.
We still in service, my lord. The entire
That is what his submission is, and there appears
Scenario
some interim order is there.
if by this interim order is continuing, my lord, then I'll take it.
Learned counsel will not gain anything by making a false statement.
No, true.
Then you could have anyway. Then your instruction will help us.
This I'll reverse sometime, my lord. Maybe
And
3.
then one thing is that is for sure. If somebody is S5, you see, cannot continue. The department has not come up for seeking vacation of the thing. So that is what you please keep in
Because
mind.
this is very intriguing for me also, my lord. If 5 years he was on interim order, department would have definitely come, my lord. Whether maybe he did not join or something, I'll just take instruction, my lord. Or he's there, I'll take instruction. My lord.
Are you sure he is there?
Yes.
Where is posted?
Second year, your lord.
Which place?
Somewhere in Manipur. Now the units are under
You
rotation.
can trace him. If you say in Manipur, are you sure you can? Huh?
He's there, my lord.
He's sending material instruction, I think.
Please.
every month.
Because receiving the material instruction, my lord.
It is submitted by the learned counsel for the petitioner that the petitioner is still continuing service by virtue of interim order passed by this court. And is discharged from service, and as such is discharged of service on medical ground is not at all tenable in view of the fact that what do you do here? That thing, when you discharge him, you say like he is incapacitated by in view of the fact that an incapable person cannot continue in service. And that itself proves the falsity of the version of the respondent's
My lord,
case.
that observation will
Just
after hearing.
do not give that.
Because what will happen, my lord?
Itself. Only you that could not have. Just what is the last part?
As such is discharged from service on medical ground is not at all tenable in view of the fact of that a incapable person cannot continue in service.
Yeah, just give a full stop. Mr. Dr. Mojika, I always miss that part. Dr. Mojika, Burnett,
DSG. DSG.
D. He will do it. He also will take instructions.
A week's time.
Necessary information, madam.
A week's time.
A week's time is granted. This is matter after?
A week. Or 10 days.
After 10 days. After 2 weeks. Make it 2 weeks. It's all right. Then
item 10.
Same.
10.
Number 10, next matter is
what is that?
Same, my lord.
Same kind of thing. Here
Yes,
also
sir.
interim order.
Yes.
Huh?
so I'll have instruction in that also. Same order will be passed in that also. If there is interim order, I'm not sure.
Are you sure there also is interim order? Mr. Jha?
Yes, my lord. पीछे है ना धर्मेंद्र and
Two persons have been.
इससे भी है ना धर्मेंद्र का भी था यार
Yes.
धर्मेंद्र का भी
Here also it seems 31/7 on the same day. So they are similarly situated.
same S5 ADS same.
And then
that's why
all alcohol dependence syndrome.
My lord, that's why I said that now
Well, the three cases
ADS
were all filed by Mr. Jha.
ADS has become a, my lord, now weapon for the.
Mr. Mojiga, you should kindly take instruction. If they are continuing for such a long time, I don't think there is any.
And how they are continuing, my lord, that is the only thing I wanted to
Definitely,
ascertain.
there is no
because
question
of
now.
stay order, they are continuing and not
I
doing
don't think
anything.
you should come and defend this case now. See, like basically, if they are continuing, so
And if they are doing well, my lord.
the same order, same. 9, 10.
Item number 11.
Well, this is a doctor cardiologist's case, my lord, from Negrims. What had happened is, my lord, because of I'm challenging the action of the respondent authorities, my lord, because of which, my lord, entire career I will be rendered 6 months junior to my colleagues, and my juniors will supersede me in terms of promotions or in terms of seniority.
Will supersede you. They have not superseded you.
My lord,
they will supersede means.
I'll be subject if my grievances are not redressed, my
You
lord.
have come against some anticipated action.
No, my lord. There's already an action which has been executed, my lord, which has already been passed, because of which, my lord, now I am already rendered a 6 months junior to my contemporaries, my lord, doctors. Here, what happened was, my lord, subject to my lord's convenience, we can continue second half, or should I continue, because this will take time, my lord.
This will take time.
Yes, my lord. I'll have to show a number of this.
You are interested to do it today, because second half.
My lord.
Or can you do it next week?
Next week, my lord. Next week, Friday, my lord, if it's possible. Friday. No. I mean this coming Friday is. Well, subject to my lord's.
I do not know. See, like if you talk about my convenience, this court doesn't know what will be convenient on.
This Friday is 25th. Because 24th and 25th, there is no division bench. The notification has come. 24th and 25th.
24th, this court also may not be in station.
24th August.
Yes.
24th or maybe 25th.
25th.
I'll go down to Bhopal.
So we'll keep next week.
We'll be leaving on, I think, 25th, isn't it? Oh, probably 25th. But then if I hear it on 24th, then if I leave on 25th, then I'll...
My lord, then...
See,
Monday,
Mr. Yubin, the
my
thing
lord.
is that, you understand, I'm taking up this hearing matters and all, but then if I'm not able to pass some order,
My lord.
then hearing becomes
Yes, my lord.
useless. It happened with other some cases also.
Yes.
That is what the problem is.
We can hear it from 28, my lord, if my lord, that's Monday, and then if not finished, then
We'll just
29.
take it up after 2 weeks then. in
My
such a
lord,
case.
my
Yes, prayed for by the parties. This matter after 2 weeks. Some more matters are there. We'll see it in the
Okay.
second half.
Please, Your Lordship, I'm for item number 13, 14, 15, my Lord. I'm seeking indulgence. May the matter taken up after a week, my Lord.
13, 15, 16. Other sides? I'm there. No problem. These are all connected matters.
Lordship.
Yes.
I have not. 13, 14, 15 after a week. As
Lordship.
per straightforward. Counsel for the votes.
Hello.
Straight to the petitioner. As per the prayer.
Hello, Lordship.
May please, Your Lordship. I will mention item number 12, Your Lordship. Your Lordship, kindly accommodate me for 2 weeks, Your Lordship.
Otherwise, you were ready for hearing, isn't it?
No, Your Lordship, since I'm not keeping well, Your Lordship, I was.
Okay, you did not make a mention in the morning.
Your Lordship, I was a bit late.
Yes, all right. I have no. Item number 12, as prayed for by learned counsel for the appellant. Is criminal appeal, isn't it?
Yeah.
Appellant, list this matter after 2 weeks.
Deeply, Your Lordship.
Any other matter remaining? No other.